this video, I want to answer the question, what happens if the substitute decision maker is incapable? And if you don't know what I mean by substitute decision maker, you might want to go back and watch that video first, and I will post it here somewhere where you can find it. So if you know what a substitute decision maker is, that is someone who makes decisions on behalf of somebody who lacks capacity to make their own treatment decisions. But what happens if that substitute decision maker, also called an SDM, what happens if the SDM themselves lacks capacity? So this is where we have to explore this idea of capacity. Hearing that a substitute decision maker lacks capacity, I would say, what kind of capacity, and want to understand more. Were they found incapable of making decisions about property? Were they found incapable of making decisions about the treatment in question? So if a patient needs antipsychotics and the substitute decision maker was found incapable of making decisions about antipsychotics, that is very relevant. If it's a different type of capacity, we would need to probe a little bit deeper to kind of figure out how these pieces fit together. But if the patient themselves is not allowed to make decisions because they lack capacity, it would not make sense to then allow their substitute decision maker to make decisions, and they too lack capacity for the same decision. So what would happen? The answer is that they would lose that right to make decisions. But what follows is much more interesting. Who then becomes the decision maker? So the answer is kind of complicated, but I'll refer to the substitute decisions maker hierarchy in the Healthcare Consent Act. There's actually a list in the law that tells us who a substitute decision maker is. And so at the top of the list is guardian, if they have a guardian of the person that was appointed by a court. Second on the list is their attorney for personal care, if the person has made a power of attorney for personal care, and down the list it goes. So we would look at where on this list does the substitute decision maker fall, and perhaps they are not the only substitute decision maker. So for example, maybe a patient has 2 children and they're both making decisions for her. That incapable patient has 2 substitute decision makers. So if one lacks capacity, the other one can continue on as the substitute decision maker. So it might be as simple as the person who lacks capacity is no longer able to make decisions, and the other person remains as the substitute decision maker, and not an awful lot changes. However, if the substitute decision maker is incapable and they are the only one at that level of the hierarchy, the healthcare provider who's proposing the treatment must turn to that hierarchy and go down the list. So maybe the substitute decision maker was the client's spouse, and now going down the list, it will be the client's child if they're 16 or older. So they will have to turn to this list. But what's quite interesting to me that I've learned quite recently, actually over several files, is that a lot of healthcare providers don't realize that it's actually pretty straightforward to do this. There isn't necessarily a lot that needs to be done. It makes sense to maybe have a conversation with the patient or documenting it in a patient record, but there isn't a legal process involved. It is the healthcare provider who's proposing the treatment that determines if that substitute decision maker has capacity or doesn't have capacity to make the treatment decision in question. And if they've decided the substitute decision maker is not capable, then they simply move down the list to the next substitute decision maker. So that's it for this video. I hope you learned something new, and I'll see you in the next one.